I'm praying the matter. Yes, Leadership.
Appointment letter, it is of recruitment of the year.
CCL 2023 Leadership. CCL has published a recruitment notice in the year 2023. Pursuant to that notification, CBT test was taken, a waiting list was published. Then again, a secondary waiting list has been published in the month of December, Your Leadership.
Who's tomorrow? Kal. We'll see the record and let the other side also be there. Counter affidavit filed.
Counter is not filed, Leadership. We have
Counter not
filed
filed.
no, Leadership. We have filed an IAS
Are you
for stay.
Inform the other side. Who is for the other side?
Mr. A.K. Das.
Call him, please. We will take up the matter tomorrow only, but please call him.
Your Ladyship, from the list, serial number 39, it was fixed by the slip, Your Ladyship. This is taking the consent from all the parties yesterday. This is a matter with respect to appointment on the post of junior engineer. I have challenged my lords that the rule says that only the minimum requirement qualification is diploma holder and thereafter they have done the higher qualification. But they are allowing the direct BTech degree holder who is holding the direct BTech to participate in the examination process, my lords, and result document verification list has also been published, my lords. Very soon they are going to give the appointment, my lords. My lords, if the pleadings is already complete, my lords, and there are judgments of different other high courts, my lords, which is in my favor, my lords, which says that for the post of junior engineer in this one, the diploma holder is the minimum eligibility criteria.
You bring the other side, then only will fix the date.
Yes, my lord. I have taken the consent, verbal consent from the GSSC.
Verbal consent.
Yesterday night, my lord, and from Manish.
That's right. Please call them. If
Yes.
they have given verbal
Yes.
consent, they will certainly appear in the
Yes,
court.
yes,
Please
yes.
call them.
Right now.
Yes, call them by 1 o'clock.
Yes.
We'll see what is to be done.
From supplementary list for final disposal item 1, WPS 2606 of 2023.
In this case, yesterday
You were not appearing yesterday,
I was not in court number 3.
so you are not supposed to appear. I've already heard it yesterday.
Yes, no. Only brought one judgment that was challenged before the division bench of Calcutta High Court, and that thereafter it was challenged before the apex court also.
Where is that?
Yes, ma'am.
Your appearance is not going to be there.
Not only an assisting counsel. Fine.
Only your assisting counsel.
Yes.
What's your name?
Ankitesh.
Ankit?
Ankitesh.
Ankitesh. How long have you been practicing?
This is actually my first.
Sorry?
This was the first time.
First case in your career? Very well done. Which college have you passed out from?
Law College, Jharkhand.
Now you just move.
Yes.
Yes. Next. This is big judgment. You have given. This is another judgment.
No, Your Ladyship, this
Did
is
you file it yesterday also?
no. This is against the for appeal. The state of West Bengal had gone for a division bench. Thereafter, they went in an SLP also.
One judgment should be sufficient. One judgment for consideration should be sufficient, or should I consider all the judgments?
It is the same.
It's on the
case.
same principle,
Yes,
isn't
sir.
it?
The main judgment is in the page number 8 of the compilation edition that I had given yesterday. Operation. Thereafter, the same was also appeared in page number 1 of the compilation. That is for Sumohan Mandal, not page number 1, sorry, page number 6. And then that was thereafter taken up in LPA and then
you have anything to say? Do you have anything to say?
Lord, Lordship may kindly consider the rule 34 of the Lord Service Code. May I refer Lord once?
Yes. Rule 34.
May I read, Lord? It is short provision. Rule 34A. Pay means the amount drawn monthly by a government servant as the pay other than a special pay or pay granted in view of his personal qualification, which has been sanctioned for the post held by him substantially or in an officiating capacity, or to which he is entitled by reason of his position in a cadre. Now he born in the cadre, my lord, only after joining.
Got it.
And my lord, so
What
far,
was the shortfall in his completion of 10 years? How much was the shortfall?
on that count, my lord, counter is, my lord,
No, it is there. The dates are there. How much is the shortfall? You calculate it in the meantime. You calculate the exact year and date.
And so far, my lord, earlier orders of the Honorable Court is concerned, my lord, there is no mentioning to give any, my lord, benefit for the period in which the petitioner was out of service.
What is the reason for non-compliance of this communication of the recommendation dated 26/5/2008 at Annexure 3? How do you explain the gap between 26/5/2008 till the year 2013? Kindly show it from the counter affidavit.
Lord, in my humble submission, my lord, at the time of joining, also, my lord, the petitioner did not raise any.
That is another thing. We want to know from
Lord,
you.
and
We will take care of that. What is your explanation from your counter affidavit for the period from 26/5/2008 till the date of issuance of appointment letter to the petitioner? No explanation?
But as paragraph 9 may can be seen. It is most humbly and respectfully stated here that after consideration this matter by the District Education Committee, however, it was found that recommendation for the appointment of teacher is received by the Jharkhand Public Service Commission through the department, and if the recommendation is found to be in accordance with the rule, the appointment action is taken. In this case, the recommendation was set at no by the Public Service Commission, and thus the District Education Establishment Committee, however, in its meeting dated 16/11/2011, decided to seek guidance from the department.
In the year 2011, after 3 years. And then you took 2 years to give the guidance. Mr. K.K. Singh, I am making it very, very clear to you and to all the law officers of the state that you do not file para-wise comment, and that is at your own peril. You do not file para-wise comments, that is at your own peril. So every averments made in the writ petition stands admitted by you.
Out of the court, I am saying that we bound to accept the statement of fact which has been used to
So
be
you are playing at their own peril. It's okay if they do not want to
that is the
file.
problem
That
we
is-
are facing. You
uh,
want to file without parawise comment, but unless
You
not
have
it
to
will be
insist
provided.
that you give parawise comment. Who will advise them?
We-
The entire state of Jharkhand is represented by a team of legal luminaries headed by none less than the Advocate General.
Lordship.
And if the authorities are not appropriately advised to ensure filing of parawise comments, then it is absolutely at your peril. You are not a novice person, a person on the street.
You will not see
Rather, we find that in number of cases, parawise comments are not being filed only because they do not have any answer to the averments made in the writ petition. And you cannot, we do not permit the petitioner to argue the case from the annexures, nor we will permit you to argue the case from the annexures. Because what is being responded to in the court is the pleadings. You can, somebody can very well just put the annexures and file it before the court with a prayer. The pleadings are meaningless then. At least this is how I see the records, and if anything contrary comes from any higher court, I will change my ways so far as pleadings are concerned. But for that I have to have some order from the higher court, maybe LP or maybe from the Honorable Supreme Court. That pleadings are immaterial, you can argue the case from annexures so far as petitioner is concerned, and the respondents, they need not file their parawise comment.
That I cannot say, but sometimes we used to take help of the supporting document also.
Supporting documents supported by statement made in the counter affidavit, isn't it? Likhiye. WPS number 2606 of 2023. The learned counsel for the parties are present. Give your appearance. This writ petition has been filed for the following relief. It is the case of the petitioner that the petitioner had participated in selection process pursuant to advertisement published by Jharkhand Public Service Commission, within bracket, in short JPSC, bracket close, for appointment of primary trained teacher. In the examination for the year 2002-2003, and the petitioner had applied for the post from the district of Jharkhand. However, when the result was published on 18/8/2005, the name of the petitioner found place at serial number 8 in the merit list of successful candidates from the district of Devghar. And consequently, the district superintendent of education Devghar issued letter informing that the recommendation for appointment of the petitioner has been cancelled by letter number 10/8/2006 on the ground of option of different district. It is further case of the petitioner that such error had happened at the end of Jharkhand Public Service Commission, and therefore the petitioner cannot suffer. And the petitioner filed a writ petition before this court in WPS number 3263 of 2007. which was disposed of by the order dated 14/3/2008. The order of the court has been annexed with the writ petition. And as per the order, JPSC had taken a stand that the petitioner did not opt for any particular place, but she opted for Jamtara. And in support of that, she had also filed a copy of the admit card. A supplementary counter affidavit was filed in the said case by JPSC, wherein it was stated that the case of the petitioner can be considered for district of Devghar, subject to the order of the court. The writ petition was disposed of, directing the respondent JPSC to consider the case of the petitioner for her being appointed as primary trained teacher in the district of Devghar as early as possible within a period of 6 weeks from the date of the order. The learned counsel further submits that the records further reveal that pursuant to such order dated 14/3/2008, passed in WPS number 3263 of 2007, when the order was not complied, a contempt case within bracket civil number 355 of 2008 was filed by the petitioner. And in the meantime, the order of the court stood complied by JPSC by memo number 660 dated 26/5/2008 as contained in Annexure 3 to the writ petition. And ultimately, the contempt petition was,
This is the order of the MPA that was referred to this.
and ultimately, the contempt proceeding was dropped by the order dated 28/7/2011 within bracket Annexure 2. The records further reveal that the order passed by the writ court in WPS number 3163 of 2007 dated 14/3/2008 was challenged by the state of Jharkhand in LPA number 297 of 2013. With the petition for condonation of delay of 1969 days. The LPA remained pending and was ultimately dismissed by order dated 24th November 2014. Though the delay in filing the appeal was condoned. The petition for condonation of delay the order of the LPA court is quoted as under. You have to quote two orders. Order passed in WPS number 3263 of 2007 and order of the LPA. It is the case of the petitioner that, in spite of memo number 660 dated 26/5/2008 issued by JPSC, which was sent to the District Education Officer Devghar, Jharkhand, yes, dated 26/5/2008. The respondents did not give joining letter to the petitioner, and the joining letter was issued to the petitioner via memo number 1649 dated 23/11/2013. By stating that the joining letter would be subject to the order to be passed in LPA number 297 of 2013. And consequently, the petitioner joined the service on 2/12/2013 and subsequently on 24 November 2014, the LPA number 297 of 2013 was dismissed. The grievance of the petitioner is the counsel for the petitioner, after giving in the aforesaid factual background, the counsel for the petitioner has referred to paragraph 13 and 14 of the writ petition to submit that due to harassing attitude of the respondents, in spite of order of the court dated 14/3/2008 and the order of Jharkhand Public Service Commission dated 26/5/2008, the petitioner was not issued any joining letter for at least 5 years, and there was no fault on the part of the petitioner, and that the petitioner joined the service under protest and filed representations dated 3/9/2014, 22/7/2014, 13/7/2017, 4/3/2022 and 22/10/2022 to the Director Primary Education and copy to other authorities seeking for regularization of the services for the period from 18/8/2005 to 1/12/2013, and for counting the period for the purposes of computing the retiral benefits, but no order was passed, and the petitioner in the meantime attained the age of superannuation on 31/12/2021 upon completing a period of how many years? 9 years and
Almost 8 years, Your Ladyship.
almost 8 years.
8 years and 11 months.
After completing 8 years and 11 months when counted from the date of joining on 2/3/2013, correct? The Learned Counsel has submitted that on account of completion of less than 10 years of service, the petitioner has been deprived of the retiral benefits. He has submitted that there was no lapses or delay on the part of the petitioner, and in spite of orders passed by this court, followed by the letter issued by the Jharkhand Public Service Commission way back in the year 2008, the petitioner was deprived of the fruit of the recommendation, and consequently the petitioner cannot be made to suffer on account of latches on the part of the respondents. In response, the Learned Counsel has relied upon the judgments passed by Honorable Kolkata High Court in Golabadan Mandal versus State of West Bengal 2023 SCC online Calcutta 2267. Number 2, Sumohan Mandal versus State of West Bengal, reported in 2018 SCC online Calcutta 13325. And State of West Bengal versus Apresh Chandra Datta, reported in 2016 SCC online Calcutta 486, and has also relied upon judgment passed by Kolkata High Court, and also referred to the appellate order passed by Honorable Kolkata High Court in the case of Sumohan Mandal, and has submitted that the appeals were dismissed against the appellate judgment. Against that, the State of West Bengal had preferred special leave to appeal bearing number 19383-19386 of 2022, which has been dismissed by order dated 1/11/2022. The Learned Counsel submits that in the case of Sumohan Mandal, Supra, in spite of order passed by the High Court directing giving appointment, the authorities giving appointment way back as on 30th October 2003, the authorities issued the appointment letter only on 15th May 2012, and consequently it was directed that the authorities will treat the petitioner as notionally appointed with effect from 30th October 2003 and grant pensionary benefit accordingly. The Learned Counsel submits that similar order may be passed in the present case. The Learned Counsel, appealing on behalf of the respondents, on the other hand, has opposed the prayer of the petitioner and has submitted that no direction as such was issued for granting appointment to the petitioner. and therefore the case of the petitioner is distinguishable from the case of Sumohan Mandal as cited by the petitioner. The learned counsel further submits that the provisions of Jharkhand Service Code Rule 34 is required to be considered inasmuch as the question of any service benefit prior to date of joining cannot be granted. He has submitted that the petitioner entered into the cadre only in the year 2013 and therefore no notional benefit can be conferred upon the petitioner in terms of the rules governing the petitioner. Upon a specific query raised by this court, the counsel for the respondents is not in a position to satisfy this court as to why the recommendation issued as back as on 26/5/2008 by the Jharkhand Public Service Commission pursuant to the order passed by this court has not been acted upon. However, in response, he submits that the matter was taken up in the District Education Establishment Committee Devkar in its meeting dated 16/11/2011 and they found it proper to seek direction from the Principal Secretary and from the Principal Secretary of the department, and consequently the direction was issued to give appointment to the petitioner only on 23/11/2013 and immediately thereafter the letter of appointment was issued to the petitioner on 23/11/2013, posting the petitioner in upgraded middle school Mathurapur, Jasiti, and the petitioner joined on 2/12/2013 and attained the age of superannuation on 31/12/2021. The learned counsel submits that all the benefit in terms of the service rules governing the petitioner with respect to post-retirement benefits has already been paid, but so far as pension is concerned, the petitioner is not entitled as she has not completed 10 years of service, which is a condition precedent.
Moreover, the service of the petitioner comes under the new pension scheme, not under the old pension scheme. Because of the initial date of appointment, even if it is considered that has been come on after the cut-off date.
The learned counsel for the petitioner has also respondents has also submitted that considering the date of joining, the petitioner would be governed by the new pension scheme and not by the old pension scheme. However, no such averment has been made in the counter affidavit filed by the respondents. What is the difference between the two?
The new pension scheme is concerned, a certain amount is required to be deposited in the scheme, and that will be paid as a pension after retirement. And so far,
What is the effective date of coming into force of new pension scheme? However, the respondents is not in a position to give the date of coming into force of the new pension scheme. Is that correct?
I am giving it.
Give it. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the foundational fact is not in dispute. This court finds that उसको पहले लिखिएगा. This court finds that no para-wise comment to the writ petition has been filed in the present case.
But that is
And-
not.
And non-filing of para-wise comment is certainly at the peril of the respondents. However, from the perusal of the writ records, including the counter-affidavit filed hearing, it is not in dispute that the petitioner had applied for vacancy in Jamtara district, and the selection list and the name of the petitioner figured in the selection list published on 18/5/2005 for the district of Devghar instead of Jamtara. This led to cancellation of the appointment of the petitioner so far as recommendation for the district of Devghar is concerned, and such cancellation was done on 10/8/2006 by JPSC. The petitioner moved this court in WPS number 14/3/2008, and as a sequel to the stand taken by JPSC in the writ petition and direction issued by the court, the letter dated 26/5/2008 was issued, wherein the name of the petitioner was again recommended for the purposes of appointment in Devghar district. It was again recommended, and the was again recommended. It further appears that the petitioner had filed a contempt petition for non-compliance of order, and the order was complied during the pendency of the contempt application. The contempt petition was number 355/2008, and on account of issuance of the letter issued by JPSC dated 26/5/2008, the contempt was dropped on 28/7/2011. The letter of recommendation issued by JPSC was not acted upon by the respondents for years together, and the matter was taken up by District Establishment Committee Devghar on 16/11/2011, wherein a decision was taken to seek guidance from the department. The counter affidavit is completely silent as to why the recommendation was not acted upon and no action was taken by the respondents during at least till 16/11/2011. It further appears that the response to such letter dated 16/11/2011 was given only on 17/10/2013, and a letter dated 23/11/2013 was issued to the petitioner in terms of the recommendation dated 26/5/2008, referring to the order passed in WPS number 3263 of 2007, and also referring to LPA number 297 of 2013, wherein the order passed in WPS number 3267 of 2007 dated 14/3/2008 was challenged by the state of Jharkhand. This court finds that the petitioner has suffered on account of laches and delay on the part of the respondents, or on account of laches and delay on the part of the respondents, and the initial error was committed by JPSC, who had recommended the name of the petitioner for the district of Devkar, but the petitioner had applied for the district of Jantar. The said error was sought to be rectified by virtue of letter dated 26/5/2008 issued by JPSC pursuant to the order passed in WPS number 3263 of 2007 dated 14/3/2008. This court finds that having recorded a finding that the petitioner has suffered on account of unexplained laches on the part of the respondents, this court is of the considered view that unexplained laches on the part of the respondents, which has resulted in serious consequences, particularly in the matter of deprivation of pensionary benefit to the petitioner, as the petitioner did not, as the petitioner could not complete 10 years of service from the date of joining till her date of retirement, and the period of shortfall was little more than 2 years.
1 year, 10 months and 22 days.
1 year, 10 months and 22 days. Taking into consideration the aforesaid totality of the facts and circumstances of this case, this court is of the view that the petitioner cannot be deprived of the retiral benefits merely by referring to the Jharkhand pension rules, which certainly provides that the emoluments commence from the date of joining. In order to balance the equities between the parties and to ensure that the petitioner is not deprived of her retiral benefits, this court directs that the petitioner, that the date of service of the petitioner would date back to previous date to a date previous to her actual joining only to the extent it completes 10 years of service to entitle the petitioner to avail pensionary benefits. The necessary follow-up orders is required to be passed by who will pass on. Respondent number 1. Right? Respondent number 1.
Respondent number 2.
By the respondent number 2, who would also consider as to whether by putting a date so as to complete 10 years of service, the petitioner would be entitled for pensionary benefits as per the new pension scheme or old pension scheme.
Lord, new pension scheme, Lord, came 1/1/2004.
Is it contributory?
Yes, contributory.
So the entire appointment is under the new pension scheme. Then it is we need not say anything because there is no change in between, isn't it? So far your argument on new and old pension scheme is concerned, that is absolutely meaningless because the entire selection process is as per the pension scheme, which may be applicable on the date of the notional date of appointment of petition. We will, that is not required, I suppose, your averments regarding new pension scheme and old pension scheme.
Just to avoid any confusion, Lord.
All right. The necessary orders be passed within a period of 1 month. LPA file करने का 1 महीना टाइम देगा from the date of filing of representation by the petitioner along with a copy of the deed records and the monetary benefit arising out of such follow-up order, and the respondent number 2 shall also take appropriate steps for release of monetary benefit arising out of such follow-up order within a period of 2 months from the date of such order. That's all. I will just, it's just an open court dictation. This judgment of the Kolkata High Court, the relevant provisions will be quoted. This is the operating portion.
Lord, one judgment I have referred to, Lord.
Which judgment?
Lord, 2020, volume 1, JLJ.
Where is that judgment?
Lord, I have given the slip yesterday.
No.
Judgment is with me.
What is it? What does it say?
Lord, I am relying upon paragraph 16, Lord.
Para 16 says what?
Lordship. While it is true that limitation does not strictly apply to the proceeding under Article 32 or 22-26 of the Constitution of India, nevertheless, such right cannot be enforced after an unreasonable lapse of time. Consideration of unexplained delay and inordinate lapses would always be relevant in writ action, and writ courts naturally ought to be reluctant in exercising their discretionary jurisdiction to protect those who have slept over wrong and allowed illegalities to fester. Fence sitters cannot be allowed to barge into courts and cry for their right.
The learned
at
counsel
their
for the respondents
convenience.
has also relied upon the judgment reported in
Lord, 2000, volume 1,
2000, volume 1,
JLJR,
JLJR
Supreme Court, page 405.
405. Para number?
Paragraph 16.
Para 16. Para 16 quote kar. So far as the judgment filed relied upon by the respondents is concerned, the same does not apply to the facts and circumstances of this case in view of the fact that the delay in latches is completely on the part of the respondents, and the petitioner cannot be said to be a fence-sitter. Rather, the petitioner had taken appropriate steps pursuant to her cancellation of appointment in the year 2006, and thereafter JPSC had also issued the letter of recommendation, but there is no explanation on the part of the respondents for not acting pursuant to such recommendation, and they filed the LPA against the order of the writ court passed way back in the year 2008 only in the year 2013, and ultimately the LPA was dismissed on 24/11/2014. In the meantime, the appointment letter was issued subject to the result of the LPA. And after the dismissal of the LPA, the petitioners have been representing before the authorities for redressal of her grievance, but no order was passed. ठीक है? अच्छा.
Lord, why I am alleging Lord this delay latches only because Lord,
कुछ तो LPA में भी बहस करेंगे.
Lord, after joining Lord in the year of 2013 Lord 14 Lord the petitioner did not take any steps for
That is
challenging-
why, because your letter of appointment was subject to the result of LPA, isn't it?
Lord, your lordship is correct, but your lordship kindly consider Lord after joining Lord in the year
Something
of 2000
has to be left to the division bench also to consider. इस कोर्ट से ऑर्डर लेना इतना आसान नहीं है, but this person has done a good job. चलिए. Yes, they had mentioned one matter.
Yes, but in that case, our counter is ready. I have shown it to my learned friend also.
File it.
Similar case, yes, by tomorrow that lady was swearing she was not well, she is joining today.
Okay.
So tomorrow I will sign it. Let it come on Monday. And similar cases, interim protection was refused. That also I have shown it to my friend. No, he was not there.
No, he was not mentioning. Some other
Some
counsel
other
was
lawyer was
mentioning.
mentioned.
Yesterday you were mentioning.
I have the order also. I
I
have
am
shown
aware
it.
about this. It may be posted on Monday and
Monday I will file it tomorrow.
Where is the counsel who had mentioned?
Leadership is on.
You just keep on changing your role.
Leadership is in court.
You are not aware what happened.
Is in court 9 is arguing one matter.
You see, he had mentioned it. We are posting it tomorrow. You file the counter affidavit during the course of the day. There is an interlocutory application. I'll pass the same. And then fix it for final disposal. Okay, what is the case number where this order has been passed?
That case number is WPS 5732 of 2023.
So we'll tag both the cases.
Yes, all the batch of cases have been tagged with this case. This may also be tagged with that.
All 2023 matters.
All 2023 matters, everything all it is. And in
You
all
come
the-
prepared with a date on which this case can be disposed of.
Yes.
सुन लिए? उनको भी बोल दीजिए. चलिए next.
For admission, item 3, criminal division 116 of 2019.
Where is the petitioner?
Serial number 3.
Yes.
Item 3, second.
Different division is the order of conviction of the petitioner law in section 138 of Kanai Act for 2 years, and fine was imposed double maximum.
Record आ गया है ना? Record has been received. Yes.
And the maximum punishment as well as the maximum compensation has been awarded. for double in amount and 2 years conviction. My case is
What
that
is,
not the,
what is your point?
my point is that the complaint has been filed prematurely.
Premature.
Yes. Service report has not been there in the record. At least
Like
you
what
got
is what is the date of the,
Yes,
give the timeline,
yes.
date of check?
Check was bounced on 10/12/12.
No, it was the date of check. 10/12/12 was the date of check.
11/12/12. Check was bounced on 11/12/12.
11/12/12 bounce.
Notice was given in 27/12/12.
27/12/12 notice.
Service report has not been exhibited.
Okay, no service report.
Means after 45 days of the legal notice, the cause of action shall arise, and the
Okay,
complaint
just
has
a
been-
moment. The 30 days expired when?
30th day, 26/12/12.
26/12/12, 30 days.
And then
Then 15 days expired when?
pardon Lord, notice was sent on 27/12/12.
Yes. It
And the
will be,
30th day is expired on 26/1/13.
okay, 130,
Yes, ma'am.
that's right.
And the instant complaint has been filed on 23rd/1/13.
23/01/13.
30.
Let us see the finding regarding service of
Yes,
notice.
Uh,
Trial court first.
I'm from
First
the
the
judgment of
trial.
the magistrate court, Lord.
Yes.
And the third page of the judgment of the magistrate court,
Yes.
which is at page number 39, sir.
39.
Yes.
Yes.
I'm on the second paragraph. During the evidence of the complainant, the above check was identified and marked Exhibit 1. Postal receipt dated 27/12/12 by which the legal notice was sent to the accused Exhibit Mark 2. Bank return memo dated 1/12/12 was identified and marked as Exhibit 3. Carbon copy of the legal notice was marked as an Exhibit 4. Service report has not been exhibited and no amendment has been made in entire judgment or in the entire trial regarding the service of the notice.
Then para number 7.
Para number 7. Heard the argument of the both sides, learned counsel for the defense argued that the above accused was falsely and
You just come to para number 9, the later portion.
Yes. Regarding the finding of the court, Lord.
Yes, para number 9.
Section 138 speaks about dishonor of the check for insufficiency etc. of the fund of the account. It speaks that where any check drawn by a person on an account maintained by him with a banker for payment of any amount of the money to another person from out of that account for the discharge in whole or part or any debt or any other liability is returned by the bank unpaid either because of the amount of the money standing to the credit of that account is insufficient to the owner of the check or that is exceeds the amount arranged to be paid from that account by an agreement made with the bank. Subsection A of the 138 speaks that the check has been presented to the bank within a period of 6 months from the date on which it is drawn or within the period of its validity, whichever is earlier. Subsection B of 138 speaks that the payee, the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid. Section C of 138 speaks that drawer of the said check fails to make payment of the said amount of money to the payee or as the case may be to the holder in due course of the check within 15 days of the receipt of the said notice. In these very case, I find that above check, which is Exhibit 1, was issued in favor of the complainant for discharge of the loan debt liability of amount of rupees 3 lakhs, but it returned by the bank unpaid because the account closed. I find that the above check was issued on 10/12/12 and it returned on 11/12/12 due to account closed, which is within the time of presentation of the above check, which is compliance of subsection A of section 138 of NI Act, I further find that the 27/12/12 legal notice was sent to the accused, which is within the 30 days.
Yes, respondent,
Yes, Lordship.
what do you have to say?
Notice was sent, Lordship.
Notice was sent when served? Service? 15 days from the date of service.
Lordship, General Clause Act Section 27 says that, Lordship.
Says what? Deemed service only 30 days.
No, Lordship.
What does it say? Look at it, general clauses act. Section 26.
ये लॉर्डशिप के द्वारा ये जजमेंट है इसमें.
Lordship, नोटिस मिल गया तो मतलब
कब मिला डेट बताइए.
नोटिस हम
ये
सेंड
लिए।
करते हैं लॉर्डशिप, तो इसका प्रिजम्पशन है कि
कितना दिन बाद प्रिजम्पशन हो?
15 डेज लॉर्डशिप.
30
कहाँ लिखा है? From where do you get 15 days?
Section 138.
138 में 15 डेज का प्रिजम्पशन है कि नोटिस भेजने से 15 दिन
नहीं,
में.
इसमें है लॉर्डशिप, क्लॉज
हाँ पढ़िए.
जनरल क्लॉज एक्ट
वही पढ़िए उसको. सेक्शन नंबर
27 लॉर्डशिप.
पढ़िए प्लीज.
Where any or regulation made after the commencement of this act authorized or requires any document to be served by post, whether the expression served or either of the expressions give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in the ordinary course of post.
कहाँ लिखा है 30 डेज या 15 डेज? कुछ लिखा है? कहाँ से आप बोल रहे हैं? आप चिट्ठी इशू कर देंगे एंड देन फ्रॉम दैट डेट इट विल बी काउंटेड.
ऐसा माना गया है.
138C, it is written in review order at page number 41.
पेज नंबर 41. व्हाट डज इट से?
Subsection 4 लाइन के बाद पढ़ रहे. Subsection C of 138 Act NI Act states that drawer of such acts fails to make payment of the said money to the payee as the case may be to the holder in the due course of the check within 15 days of the receipt of the
Receipt
said
of the notice. Issuance of notice is different from receipt of notice, or they are one and the same thing. They are not one and the same thing.
Once notice was sent, it is deemed to be
Served when? Uh, 30 days.
38.
On 38th day, it will be deemed to be served. Same terms.
Yes.
We have passed many orders on this.
Lordship, one judgment my CCL
Yes. Para number?
para number 17 Lordship.
Para number?
17.
70. Yes. Kindly read.
लॉर्डशिप, इनको नोटिस नहीं मिला लेकिन इनको सम्मन मिल गया था ट्रायल कोर्ट में सम्मन मिला, तो इस वक्त प्रिजम्पशन माना जाएगा कि इनको सम्मन मिल गया तो उनको 15 दिन के अंदर इनको.
Kindly read.
It is also to be borne in mind that the requirement of giving of notice is a clear departure from the rule of criminal law, where there is no stipulation of giving of a notice before filing a complaint. Any drawer who claims that he did not receive the notice sent by post can, within 15 days of receipt of summons from the court in respect of the complainant under section 138 of the Act, make payment of the check amount and submit to the court that he had made payment within 15 days of receipt of summons by receiving a copy of complainant
Evidence.
with the summons, and therefore the receiving a copy complainant with the summons 15 days. 15 days of receipt of the summons from the court along with the copy of the complainant under section 138 of the Act cannot obviously contend that there was no proper service of notice as required under section 138. Service notice का required नहीं है उसमें.
Lordship, in this para itself, reason has been assigned. I am further reading, may be permitted. In the complaint of discharge of loan debt, liability of amount 3 lakhs, but it returned by the bank. This very case, I find that above check, which was Exhibit 1, was issued in favor of the complainant for discharge of the loan liability of amount of rupees 3 lakhs. But it returned by the bank unpaid because of the account was closed. I find that above check was issued on 10/12/2012 and it is returned on 11/12, next day. Next day it was returned due to account closed. Then he has issued when his account was closed, then only the check was issued.
So
Then his intention was.
that's
showing
right, every intention was the timeline is required to be followed. The question of filing a complaint case, the complaint case becomes premature. You see, the person can say, if the complaint is filed by following the timeline, suppose a complaint is filed after expiry of 30 days of issuance of notice, then one can say that it is a rebuttable presumption that the notice has been served. And suppose a person takes a plea that notice was never served on me, then this particular judgment which he has cited will come into play. But here is a case where the deemed service of notice would not have been assumed in the fact that 30 days had not elapsed from the date of issuance of notice.
Further, it has written, I further find that on 27/12, legal notice was sent to the accused, which is within the 30 days as per the requirement of subsection B of section 138 of NI Act, and despite the receiving of the notice, the above amount.
What is the date of receiving of notice? This is what I am asking you. Show me what is the date of receiving of the notice. Notice can be served even on the next day. But is there any date of receiving of notice? In his evidence also, he has not mentioned a word about the date of receipt of notice. Not even a word. Tell us from the impugned order.
Presumption under 139.
139 the presumption will be when? Presumption under 139 is that the check has been issued against a debt.
Yes.
That is only presumption.
Yes.
Show me some law that if a person issues a notice, then the date will start commencing from the date of issuance of notice, date of service of notice. So in this particular judgment, we have not non-suited you completely. That liberty to file a fresh case with explanation of delay is there. You can just have a look at it.
Yes,
उनको
one
दिखाइए,
more
उनको
judgment of
दिखाइए,
Honorable Supreme Court.
उनको दिखाइए.
He has a liberty to file a fresh complaint
Yes,
regarding
yes,
the same.
yes.
2014 it was quoted by the Honorable Supreme Court also.
Yes. Okay. Heard the learned counsel for the parties. The counsel for the petitioner submits that the only point involved in the present case is that the complaint itself was premature, and therefore the complaint for bouncing of the check was itself not maintainable. He submits that although the learned courts have recorded that notice was served, but no date of service of notice has been mentioned in the impugned order, and even as per the evidence of the complainant or the evidences produced on record, there is no date of service of notice. The learned counsel submits that the notice was sent under registered cover, and the question of presumption of service of notice would arise only upon completion of 30 days from the date of issuance of notice, and thereafter more 15 days is required to be granted to the accused to discharge to make payment to the check amount, and then only the cause of action to file the complaint case arises under the provisions of Negotiable Instruments Act. By giving the timeline, the learned counsel has stated that the check is dated 10/12/2012, It bounced on 11/12/2012. The notice was sent by registered cover on 27/12/2012. 30 days expired on 26/1/2013, and the case was filed on 23/1/2013.
14.
2013.
14. It is the typographical error in the judgment. 14.
तो 12 के बाद 2014 में केस फाइल हुआ.
13 में फाइल हुआ.
30. Pardon me. 30.
13.
Pardon. I was in the.
Was filed on 23/1/2013. The learned counsel submits that even if it is assumed that the notice was served by 26/1/2013, the period of 15 days had not expired on the date of filing of the case. यही है आपका?
Yes.
The cause of action to file the case could arise only after expiry of 15 days from 26/1/2013. The learned counsel has relied upon a judgment passed by this court in Criminal Revision number 827 of 2012, decided on 13/7/2021, which in turn had relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2014, bracket close 10 SCC 713. And also the judgment reported in bracket 2008, bracket close 13 SCC 689. and other judgments of the Supreme Court, and has held that the case was premature. The learned counsel appearing on behalf of the respondents, on the other hand, while opposing the prayer of the petitioner, opposite party number 2, on the other hand, while opposing the prayer of the petitioner, has submitted that the notice was issued on 27/12/2012, and the petitioner ought to have paid the amount upon receipt of the summons. And for this, he relies upon a judgment passed by the Honorable Supreme Court reported in bracket 2007, bracket close 6, SCC 555, para 17.
Service notice are not required.
Oh, the learned counsel has also submitted that service of notice is not required to be proved. This is what you want to say. The learned counsel appearing on behalf of the state has referred to the impugned order to submit that since the check had bounced on account of the fact that the bank account itself was closed, therefore there can be no dispute that the petitioner never intended to clear the debt, and there is a presumption in favor of the complainant, and therefore the impugned orders do not call for any interference. However, from the आप लोग का सबमिशन का ऑब्जर्वेशन लिख रहे हैं, ध्यान दीजिए. However, in spite of granting an opportunity to the respondents to show the date of service of notice from the impugned order, the learned counsel for the respondents have fairly submitted that there is no specific date regarding service of notice to the petitioner as is reflecting from the impugned orders and from the records which they have perused and received from the learned court.
Postal receipt is
Marked as
They simply submit that the postal receipt of sending the notice has been exhibited, which was
27/12.
dated 27/12/2012, which was sent through registered cover. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the aforesaid timeline regarding issuance of check and its bouncing is not in dispute. Admittedly, the notice for notice regarding bouncing of check was issued on 27/12/2012 through registered cover. Admittedly, there is no service report regarding the notice. Considering the ratio of the honorable this court in criminal revision number 827 of 2012, this court is of the considered view that in absence of specific date regarding service of notice, the notice can be deemed to have been served only upon expiry of 30 days from the date of its issuance, and thereafter 15 more days as per, is given to the accused as per the provisions of Negotiable Instruments Act to make payment of the amount, and only thereafter the cause of action to file a complaint case arises. In the present case, the complaint case has been filed prior to expiry of 30 days from the date of issuance of notice dated 27/12/2012. The 30 days expired only on 26/1/2013. This court has gone through the evidence of the complainant before the learned trial court and finds that even in the evidence, the complainant has not mentioned anything regarding service of notice. Rather, the complainant had only stated that on 27/12/2012, a notice was sent granting 15 days time to make payment, failing which legal action will be taken. In view of the aforesaid facts and circumstances, this court is of the considered view that the complaint was premature. Just a moment. This court, इसका paragraph number 23, 24, 25 and 26 ले लीजिए, ठीक है? And then a few paragraphs from here, I will just quote that. And then in terms of para 41 of the judgment passed in by the Honorable Supreme Court, reported in para 2000, reported in bracket 2014, bracket close 10 SCC 713. The Honorable Supreme Court, while holding that the complaint was premature, also observed in the judgment itself that the remedy for the complainant is to file a fresh complaint satisfying the court regarding sufficient cause of delay. The present revision is allowed and the parties may proceed as per law. The parties may proceed as per law, and so far as the judgment passed by the Honorable Supreme Court reported in bracket 2007, bracket 06 SCC 555 is concerned, the paragraph 10 of the aforesaid judgment clearly holds that where the payee dispatches a notice by registered post with correct address of the drawer of check, the principles incorporated in section 27 of the General Clauses Act would be attracted. The requirement of clause B of proviso to section 138 of the Act stands complied with, and cause of action to file the complaint arises on the expiry of the period prescribed in clause C of the said proviso for payment by the drawer of the check. Nevertheless, it would be without prejudice to the right of the drawer to show that he acknowledged that the notice was brought to his address. Paragraph 1, paragraph number 10 ले लीजिएगा, para 15. It has been held in paragraph 15 that it is well settled that at the time of taking cognizance of the complaint under section 138 of the Act, the court is required to be prima facie satisfied that the case under the said section is made out and the mandatory statutory procedural requirements have been complied with. It is then for the drawer to rebut the presumption about service of notice and show that he had no knowledge that the notice was brought to his address, or that the address mentioned on the cover was incorrect, or that the letter was never tendered, or that the report of the postman was incorrect. The Honorable Supreme Court also observed that the interpretation of the provision would effectuate the object and purpose for which the proviso to section 138 was enacted, namely to avoid unnecessary hardship to an honest drawer of check and to provide him an opportunity to make amends. The Honorable Supreme Court in paragraph 16 also observed that the entire process of requiring a notice to be given an opportunity to the drawer to pay check amount within 15 days of service of notice and thereby free himself from the penal consequences paragraph 17 of the aforesaid judgment is quoted as under. This court, in the said case, in the complaint it was averred, as mentioned in paragraph 18, that the complainant had issued lawyer's notice intimating dishonor of check and demanded payment on 4/8/2001, and the same was returned on 10/8/2001, saying that the accused was out of station. This court is of the considered view that unless the timeline prescribed under the provisions of section 138 and other related provisions are satisfied, the complaint itself was premature, and therefore said judgment relied upon by the petitioner reported in bracket, relied upon by opposite party number 2 reported in bracket 2007 bracket 6 SCC 555 does not apply to the facts and circumstances of the case where the filing of complaint itself was premature. It is not a case where the petitioner is asserting that the petitioner had not received the notice at all. Yes, what do you want to say?
He had not laid any evidence that he had not received notice.
Need not.
And paragraph 17 of my judgment, that when he received notice from the summons from the court.
I have considered it.
Yes.
I have heard it.
Yes.
The timeline is required to be followed.
Yes.
And the right to file a fresh complaint is there.
Yes.
You can do that. There will be lot of corrections in the judgment, but I have allowed it with that liberty
Yes.
to act as per law.
Okay.
Lot of quotations are there from various complaints.
Item 4, WPS 1614 of 2023.
Yes, petitioner.
Last order passed by the Supreme Court on 25/1/24.
Yes.
That is the only my submission.
Can you read it?
And as per the order of this Supreme Court, I have already given a representation before the, though I have not got out of supplement by the way of affidavit on record, but I have given the representation and for my joining, but still what my client has said that they have not taken the joining of the petitioner till date.
What is the fact? You just can't argue a case from
No,
the
no,
order sheet. This order sheet was not even drawn by me. I have never seen this record earlier.
That is, the fact is that also that the petitioner's prayer is that the respondent be directed
This
for
was
taking his joining,
a revision will happen.
to accept the joining of the petitioner.
What is the date of your appointment?
Logically, initially he was a paragraph 5, the date of appointment is 29/2005.
That's right. Then,
Lordship, he was in continuous in service.
yes.
Then a leave was sanctioned from 19/11/2016 to 25/11/2016. But due to some problem,
19/11/2016. Where is the sanction of leave?
Lordship, that has not been brought up.
Then, from where do you say that there was a sanction of leave?
It is a statement, Lordship, that from the statement.
Where is it? 19/11/2016 to 25/11/2016.
And thereafter, Lordship, he has not able to join the service.
What
As
is
you-
the response to paragraph number 6?
Yes.
Have they admitted it?
No comment. They are admitted. They are admitting that. They are admitting.
Sorry?
Lordship, the case is that, Lordship.
No,
that
please let him finish.
They are accepting my my joining that I was working with them, but they are not accepting my joining.
Just. Then what happened? When did you give your joining?
Lordship, I went to give joining just after my recovery, but still that they are not taking my joining. Even Lordship, the order passed by this honorable court, I was drawn the attention of my lord on 25 or 24. Even thereafter, I have filed an application before them, but they are still not taking my joining.
What is Annexure 3 series?
Annexure
3 series. Have you drawn any disciplinary proceeding against him?
Lordship, for that purpose, I was, Lordship, seeking some time.
No, please, I will not grant you any time. Have you initiated any
Lordship,
disciplinary proceedings against him? Yes, he says yes. You see, these things can be seen only in the disciplinary proceedings.
Yes, Lordship.
How do we see it in the writ records? You participate in the disciplinary proceedings.
So unless and until, Lordship, unless and until they withdraw the disciplinary proceeding, or
They will not withdraw the discipline. You go and participate and explain that you were under some treatment, you were not well. This has to be examined in the disciplinary proceedings. We can't give any finding that you were, because you were in a hospital or under some mental treatment of mental.
that I am not saying. Even if Lordship sees my period is to the only to the extent that they at least they may allow me to join my service, and they may draw my proceeding.
They have already drawn a proceeding.
No, they have not drawn the proceeding.
They have. Have you drawn any proceeding?
Lordship, we have advised that the petitioner may be joined and thereafter departmental proceeding may be conducted against the petitioner, Lordship.
Where have you stated?
Lordship, for that purpose, we have not brought it on record, Lordship. It has to be brought. We have seek all the documents from the petitioner, that is an exact E, Lordship, for that purposes.
Annexure A.
Annexure E, page number 20.
What is Annexure E?
Annexure E says that, Lordship,
Kindly read it.
married. It
They have called for an explanation from
Yes.
you.
Yes.
You respond to that.
Yes, I will respond. I have already responded. I have already responded then.
Then they will proceed as per law. Either they
But
will draw
they-
a disciplinary proceeding or they will permit you to
My
join.
lord, that is my submission, but they are not proceeding against me.
They will. It is 31/3/2023. And you, when did you file this case?
Lordship, it is filed
On 23/2023.
23.
Just immediately thereafter this letter has been issued, isn't it? To which you responded.
I have also responded recently. I have responded and as per my client's instructions that he only responding time to time responding.
They
Time
will
to
take a
time-
decision on this. They have already issued you a show cause.
My lord,
You have responded to it. They will take a decision on this and proceed in accordance with it. That is all. We cannot decide.
no, I am not saying that you might not be decide that my absence was the unauthorized absence or what is it. My submission for Lordship is that if they give me joining or they may draw proceeding against me for my unauthorized absence or whatever may be there.
You see, in order to draw a proceeding also, you have to give him joining. You
Yes,
can
ma'am.
put him under suspension
Ma'am.
and do whatever.
Uh-huh.
And then for the intervening period, you can have an order whether he will enter
That is
back
all,
wages or
madam,
not
madam.
back wages, because till now you have not terminated his service.
So that is
Lordship, that was the observation of this honorable
WPS number 1614 of 2023, the learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was working under the Department of Health, Government of Jharkhand, and since 2005. However, the petitioner was granted leave from the period from 19/11/2016 to 25/11/2016 for treatment of his mother. A statement to this effect has been made in paragraph 6 of the writ petition. Thereafter, the petitioner asserts that the petitioner was suffering from mental illness and was under treatment in various hospitals during the period from 21/11/2016 to 10/2/2023, and after obtaining certificate of medical fitness, he made a representation on 17/12/2023 before the Director-in-Chief, Health Services, Government of Jharkhand, Ranchi, respond number 3, for accepting his joining, but no action was taken.
Lordship, that is 17-2.
17/2/2023, but no action was taken, and consequently the present writ petition has been filed. The learned counsel submits that the counter affidavit has been filed in the present case, and the averments made in paragraph 6 of the writ petition has not been denied. The learned counsel further submits that the records indicate that no order of dismissal has been passed so far against the petitioner.
During the
He
period,
has submitted that during the pendency of this writ petition, a letter dated 31/3/2023 was issued to the petitioner calling for an explanation for unauthorized absence, to which the petitioner has duly responded, but to the best of his knowledge, neither any disciplinary proceeding has been initiated nor the petitioner is permitted to join. The learned counsel has submitted that even if any disciplinary proceeding has to be drawn against the petitioner can certainly be put under suspension and appropriate action can be taken, but the joining of the petitioner cannot be denied by the respondents. The learned counsel appearing on behalf of the respondents has submitted that, as per the counter affidavit, the show cause was called for, the petitioner has responded, but he is not aware about the present status of the case.
that has been not brought on record by the petitioner, whether they have responded or not.
Response है
No, Lordship, that is a letter issued to the petitioner.
Then next page, page number 21.
It is of 2016 letter.
Okay. The learned counsel submits that it has not been brought on record by the petitioner as to whether the petitioner has responded to the show cause dated 31/3/2023. However, from the counter affidavit, it is not in dispute that so far the petitioner has not been dismissed from service. From the counter affidavit at least. After hearing the learned counsel for the parties and considering the materials placed on record,
Lordship, by annexes, we have written to the petitioner several times
that's
that he may give his joining during the period of being absent, Lordship.
okay. The learned counsel for the respondents has also submitted that during the period of absence of the petitioner, several letters were issued to the petitioner to give his joining, but the petitioner did not give his joining.
Petitioner has not even responded.
And the petitioner did not even respond to the letters
no
issued.
relatives of the petitioner also intimated regarding the illness of the petitioner.
That's right. And the petitioner did not intimate the respondents regarding his illness. Do you expect a person who is under treatment in mental hospital to respond to your letters?
As per Lordship,
We'll see that.
any of his relatives.
We don't want to say. We don't want to say anything more. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that there has been long absence of the petitioner, at least from 21/11/2016 to 10/2/2023. And the petitioner claims that he was under treatment of various doctors. It further appears that the petitioner gave his joining on 17/2/2023, but the same was not accepted by the respondents. And no order was passed on the same. The counter affidavit reveals that a show cause was issued to the petitioner on 31/3/2023. But it is not clear from the records as to, for his long absence, but it is not clear from the records as to whether the petitioner had responded to the same or not. However, from the counter affidavit, it appears that the petitioner has not yet been dismissed from service, and certain show cause was issued to the petitioner to furnish his explanation. In such circumstances, this court is of the considered view that the joining of the petitioner could not have been refused, inasmuch as it was certainly for the respondents to proceed against the petitioner for his unauthorized absence by instituting a departmental proceeding against the petitioner. And for that purpose also, the joining of the petitioner would be required. Certainly, the petitioner can be put under suspension if the authority so considers proper. But in such circumstances, the joining of the petitioner is directed to be accepted, and such joining as well as any relief to the petitioner would certainly be subject to the disciplinary proceeding if instituted against the petitioner.
Yes.
Right?
Yes.
The needful be done with regard to joining of the petitioner within a period of 15 days from the date of receipt of the copy of this. So, petition is accordingly dispatched.
From there it is item 3, WPS 3043 of 2022.
Yes, petitioner.
Petitioner management has challenged Annexure 5, which is the reference itself. Should the reference relates to dismissal of the respondent, there is a reference, Lordship, even though after holding the inquiry and passing the order of punishment, which is at Annexure 2, an approval application was also simultaneously made under the provisions of section 33(2)(b) proviso, because there was a previously pending reference case before the industrial tribunal, and therefore the management was bound to comply with the provisions of section 33(2)(b) by filing an approval application. Not only did the management file an approval application, even
Prior to dismissal or post dismissal?
simultaneously with the dismissal. The order mentions on the same date, all the three has to be done simultaneously: issuance of dismissal order, making of the application and giving 1 month's pay. That is the requirement under 33 2B proviso. When
it can be done simultaneously.
it has to be done simultaneously.
Prior permission is required.
Prior permission is required under section 33(1) when the action is connected with the earlier reference. Here
This
it
is not
was
connected?
not connected, it was of general nature relating to wages.
What was the proceeding, what was the allegation in connection with which the proceeding was pending before the court?
Rashid, the previous reference was general nature. Against him, the disciplinary proceeding was for first absence, and when the show cause was given, the workman comes to the gate of the factory, uses abusive language and slogans for which the charge is amended and a second charge is added of using filthy and abusive language. Department inquiry is.
So all the materials are on record?
Lordship, only the state has not filed a counter despite it being impleaded and despite repeated adjournments.
Why was state impleaded?
Lordship, the state was impleaded because I have challenged the reference itself, Lordship. And in the alternative, Lordship, there is also a challenge to Annexure 8 because in the Labour Court, we had filed a petition that since there are 2 more cases pending in the tribunal in relation to the same incident, one filed by him under section 33 capital A, alleging that you have violated section 33,
That's right.
and we had filed another case 2 of 2021.
What happened
and
in those cases?
both those cases are pending. No, he has made a statement subsequent during the pendency of these proceedings that I have withdrawn without bringing on record any order. I have also,
You
without
also
giving
bring
to me
on
any
record?
copy.
You can also bring it on record.
Lordship,
Because if he files a petition
no,
under
Lordship,
section
what has
33
happened is that the tribunal is not functional.
Which tribunal is
Industrial tribunal is not functional for last over 4 years.
Where?
Ranchi, Lordship. The state industrial tribunal is not functional for last over 4 years.
So you are not unable to get the records.
No, Lordship, we can get the record, Lordship, but he has only made a statement. We have said that we have not received, the tribunal is not functioned. He never served a copy for withdrawing, which says he has done during the pendency of the writ petition. But in any view of the matter, our approval application is still pending, and the punishment order itself is inchoate, and therefore the reference on this issue of dismissal when the approval application itself is pending and the procedure is not complete, the dismissal
Where
is
is the
yet to
state?
come to fruition.
You have not filed your counter affidavit?
We will file it within 3 weeks time maybe.
It is proceeding in the labour court and it is now
It was
almost
by
at
way
the
of last
stage
chance.
evidence. So Lordship,
You
only
rejoinder to counter affidavit. You have filed your rejoinder?
I have filed rejoinder to his counter affidavit, Lordship, the workman's counter affidavit.
And the court is proceeding because
The
there
court
is a
is
specific order
The
that
court
there
is
will be no
proceeding.
hindrance.
Yeah, and they are taking adjournment. So by last order 30/11/2023, it was directed to be posted for final disposal. That is why it has come for final disposal.
What is at stake? You want to make this case infructuous?
No, Lordship.
Then your reference is under challenge in this case and you are sleeping over it. And ultimately the reference will be decided and the case will become infructuous. You are happy with that? There is very little scope in interfering with an order of reference, but still, when there is an order to file counter affidavit, you have to file it.
Yes, Lordship.
How much time do you need?
3 weeks time maybe even.
3 weeks? Who is the person who will give you instruction? We will ask him to give instruction. You tell us. You are unable to control your officers.
As your Lordship deems fit.
Yes, who is the person who will give the instruction? Tell us. Who will give you the instruction? The Secretary, Department of Labour?
Yes, sir.
The learned counsel for the parties are present. The order of reference issued by the government of Jharkhand, Department of Labour, Employment and Training is under challenge. No counter affidavit has been filed on behalf of respondent number 3. that is the Secretary, Department of Labor, Employment and Training, Government of Jharkhand. In spite of order dated 17th of August 2023. Now, in spite of order dated 12/6/2023 and also seventeenth of August 2023. Today, when the case is taken up, the learned counsel for the state is seeking time to file counter affidavit. Let the counter affidavit be filed latest by. You have taken up the matter with the state?
Yes, Lordship. We
You have issued letter?
Yes, Lordship.
What is the date of your letter?
Lordship, it has been intimated on 12th of July and 24th August, Lordship.
The learned counsel for the state has submitted that the necessary intimation has to the concerned authority has been done through communication dated 12/7/2023 and 24/8/2023, but no response has been received so far. Let the since the notification issued by the state government by the state is under challenge, in order to proceed further in the present case, the counter affidavit of the state would be required. However, accordingly, time till March 18th is granted to the respondent number 3 to file the counter affidavit in this case by way of last indulgence.
Lordship, it should be respondent number 4, Labor Commission, not such thing.
No.
The reference
It
is done by
should
the
come by
secretary.
respondent number 3 by way of last indulgence, failing which the case will be decided on the basis of materials available on record. Do we need the lower court record की जरूरत पड़ेगी कि नहीं पड़ेगी?
कोई जरूरत नहीं
कोई जरूरत नहीं. Just a moment.
क्योंकि ये सीपीसी का जो प्रोविजन लिए हैं
फिर बाद में मत बोलिएगा कि लोअर कोर्ट रिकॉर्ड चाहिए. Do you need?
I'm only on the point of jurisdiction that the reference is itself.
All right.
The only problem is that my IA has also remained pending. There is a pending IA for stay
Please
also,
go.
and it is now
Please
almost
go.
at the end of evidence. Because they have hurriedly conducted the evidence, the inquiry has been declared to be unfair. Now we are proving the charges in the labor court. It has gone to that stage within
Just
1 year.
हुजूर 33
कोई बात नहीं, आपको सुनेंगे आप चिंता मत
3(2)B में देखा जाए हुजूर जो चेक दिए हैं, चेक इन्हीं का कितना गलत कि वह ना मजदूर को दिए है ना बैंक में डाले और खाली फेक चेक यहाँ दे दिए. तो हम माननीय विद्वान अधिवक्ता से कहते हैं कि शपथ पत्र
आपकी
दें.
बात सुनेंगे, आपकी बात सुनेंगे, आप चिंता नहीं करें. By 18th of March 2024,
श्रम विभाग को मानते भी नहीं है, वार्ता में जाते भी नहीं है। गलत चेक लगा दिए।
Let a copy of this order be communicated to office is directed to communicate a copy of this order to respond number 3. Mr. Bakshi, when the evidence is going on, what order can be passed at this stage?
Because we have challenged it on the ground of jurisdiction.
That's right.
And according to national engineering case,
You see, we can test him. When the evidences are going on, then under such circumstances, the point which has been raised here, we can keep it open for you to raise it. The reason is that when the evidences are going on, there are so many nuances. That would be better, I think. Think it over, right? Because if that jurisdictional issue, whether a reference can be made during the pendency or whether that is itself quite a nuanced thing, isn't it? So therefore, I can post it on 19th, but I think that should be good enough for you, for all the parties.
Only difficulty is that the punishment order itself is inchoate. It has not yet come into full force.
That's right.
Because
So
the procedure
is there
is
any
only
legal
when
bar?
it is approved.
Mr. Bakshi, please tell us, is there any legal bar from raising these points if we observe that these points can be raised?
No, I can raise my dismissal order is only complete when I get approval from the tribunal.
We appreciate that.
And before that, the
appreciate
labour court will hold the action illegal before it can be
therefore,
approved by the tribunal.
So therefore, the points that you have raised here can be left open for consideration before the court, where then under such circumstances you will have some adjudication on that and you can agitate, because in the midst of a proceedings which is still going on and evidence has been led to some extent, is it proper to unnecessarily curtail the proceeding and pass an order on the point of jurisdiction?
I'll only satisfy on the ground
I'm
if
just
it is
posting,
without jurisdiction.
I will
then
just.
only then I know
I'm just indicating.
Grounds.
I'm just indicating. I'm posting it on 19th, and this is what I'm going to do.
And there is also one more limitation under the even the national engineering case says that the labour court itself cannot refuse to decide the reference. So therefore, you have to go under Article 226 to challenge a reference, because the labour court cannot say that this reference is bad or I refuse to answer the reference. So labour court is bound by the reference, even though wrongly
you
made.
cite those judgments.
I'll cite those. I'll bring.
You cite those judgments. We'll see that. What is the citation of that?
That is national engineering. Please. 2000 volume 1. I have a copy. I have extra.
Kindly give the copy.
आपको भी दे दें.
Post on 19th.
जी.
Council get ready on that day.
यूज मजदूर ऐसे ही निकाल दिए, इनकी पत्नी जिस दिन निकाले उसी दिन मर गए, हार्ट अटैक कर। बेटा इनका अभी अति है और एकदम अकारण।
देखिए ऐसा है,
यहाँ तक कि वार्ता में नहीं जाते हैं वो।
ऐसा है कि आप इनको रिप्रेजेंट कर रहे हैं, इट इज बीइंग रिप्रेजेंटेड थ्रू द यूनियन।
जी।
You are, or he is individually fighting his case.
He is representing.
Representing him here, and in the labour court he is individually fighting.
There also he is representing. वहाँ भी representing.
No, we do not know. Here who is the party?
धर्मेंद्र कुमार.
In personal name he is the party?
जी.
Then you can't represent him.
Section 36 does not permit.
No,
this
you
is
can't
226.
represent him. इनको आपको वकालतनामा फाइल करना पड़ेगा. We will not permit you.
36 देख
नहीं, या तो वो खुद बहस करेंगे या कोर्ट में वकील साहब बहस कर सकते हैं, आप उनको रिप्रेजेंट नहीं कर सकते हैं, यहाँ पर नहीं कर सकते, लेबर कोर्ट में आप रिप्रेजेंट करेंगे। नहीं, यहाँ का नहीं, आप नहीं कर सकते, यू जस्ट कांट, एनीबडी कांट डू।
यही बहस करेंगे।
हाँ, यही बहस करेंगे, अपना करेंगे। इनका नाम लिखिए। party in person, give his appearance. Court में ऐसा नहीं चलता. या तो party in person will argue the case or some advocate will argue the case in the High Court.
Item 4, WPS 2961 of 2023.
Get that order also on the record. Whereby they have withdrawn. If you are able to get it, you take it.
I'll try.
Yes, petitioner.
This petitioner is mentally challenged, my lord. Pursuant to direction of your lordship, my lord, now counter has been filed. Wherein at paragraph 11, they have brought on record that the matter has been referred to the Accountant General Bihar.
It has become infructuous.
No, my lord, since the petitioner is a mentally challenged person, my lord, and even if they have referred it to the Accountant General, my lord,
Referred for what?
for fixing the family pension.
What else?
But difficulty is that still she will have to run from pillar to post.
She will have to be represented. A person who claims that he is mentally challenged,
May I
the other
request-
cannot even execute a wakalatnama for that
My
purpose.
lord, she is partially.
So
My
therefore,
lord, may I submit one thing?
nothing is to be done. We will just expedite your claim.
I
Don't
may
worry
be
about it.
permitted to plead state of Bihar and Accountant General.
No, they have already referred it for payment.
Still the practical difficulties.
There is no practical difficulty.
Not
You
easy,
can have legal
not
aid, you
easy
can
to
have
retrieve
legal
money,
aid.
my lord. Therefore,
You will get
special circumstances.
No,
this
no,
accommodation.
nothing.
Because twice this is second round of litigation, my lord.
I appreciate.
Therefore, one indulgence may be given, subject to my lord.
No, the matter has now been referred to. What is the annexure? Where have you stated?
Counter para 11 this. Annexure A.
Annexure A at page number 17, your lordship.
At least it, if not pending, my lord, then sufficient direction. my lord.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. A counter affidavit has been filed in the present case. Paragraph
11.
just a moment. Seven to 12 of the counter affidavit is quoted as under. The learned counsel for the respondents has submitted that appropriate steps has been taken for the purposes of redressal of the grievance of the petitioner. Now the Office of Accountant General, Patna, Bihar, has to take steps for the purposes of payment of family pension to the petitioner. She submits that for all practical purposes, the present case has become infructuous. To this, the learned counsel for the petitioner submits that, considering the mental status of the petitioner, some direction may be issued such that there will be such that there may not be any further impediment or harassment of the petitioner in obtaining the benefits which the petitioner is otherwise entitled. After hearing the learned counsel for the parties and going through the counter affidavit, this court finds that appropriate steps have been taken and the matter has been referred to the Office of Accountant General Bihar. This court finds that the appropriate follow-up order is required to be passed by Accountant General Bihar Patna, and therefore no purpose will be served by keeping the present case pending. However, considering the argument of the counsel for the petitioner regarding the mental ailment of the petitioner, this court is of the considered view that the petitioner is entitled for legal aid, and as the matter relates to Accountant General stationed at Bihar, Patna, Accountant General Bihar at Patna, the petitioner, the Jharkhand State Legal Services Authority is directed to ensure that petitioner is granted appropriate legal assistance in the matter of following up the matter with Accountant General Bihar, Patna. It is further observed that the Accountant General at Patna shall also take special care that the grievance of the petitioner is redressed by is ultimately redressed within a period of 2 months from the date of submission of the documents as mentioned in letter number 190 dated 2 नहीं ये तो भेज दिया ना
जी
okay redressed within a period of 2 months from the date of communication of this order. This should suffice.
My lord, it may be indicated, my lord, if it is not addressed, my lord, that petitioner is at liberty to approach this order.
That is always
My
there.
lord, that is there, but it will have some
District
effect.
petition is accordingly disposed.
But because in special circumstances I am requesting this.
You should give legal aid to them.
I am ready and I am giving, my lord.
You better give.
Item 5, WPS 3864 of 2023.
So the last one, I'm going to do supplementary affidavit not as the petitioner has been acquitted, not by the trial. For the same set of affidavit, exactly the verbatim same, the memo of charge.
Where is you have filed a supplementary?
Yes, Lord, I have filed it. I have put it in the record on 6th. I filed it. 1/3/2024.
Respondent is absent. The counsel for the petitioner is present. Nobody appears on behalf of the respondents. The petitioner submits that the order of acquittal has been, but no counter affidavit has been filed.
Counter-affidavit they have filed, Lord. Counter-affidavit they have done on the same day.
Posed this case on 10th of April 2024. In the meantime, the parties to file list of dates, short synopsis of arguments, and the judgments which they seek to rely upon. Latest by 4th of April for final disposal. नहीं 4th अप्रैल तक फाइल करना है 10th अप्रैल हाँ 10th
Item 6, WPS 4593 of 2023.
petitioner
You have to file a counter affidavit. I have served a copy to him, but could not file it.
yes
My counter is ready right here.
okay where is the petitioner absent yes what do you have to say
Your Ladyship, in the counter, they are stating that as per clause, the employment for female candidates would be governed by clause 9.5.0 of NCW. But as per clause 9.3.3, they have already defined for the dependents. And in 9.4.0,
you want to respond to the counter affidavit
no,
or
no, Your Ladyship, it may be decided.
the clauses of the agreements are there?
Yes, annexure.
Tell us, what do you want? Ati?
Your Ladyship, petition number 1 is the widowed daughter-in-law of the deceased employee. The petition number 2 is the wife of the deceased employee. She has submitted an application for compassionate appointment for her daughter-in-law itself. The management has rejected that application.
Saying what?
Stating that since the direct dependent is available, the indirect dependent moved in employment, you will get monetary compensation only.
Who is the direct dependent?
The wife of the deceased. In paragraph 16 on page.
The wife does not want monetary compensation.
No.
She is otherwise eligible.
No, Your Ladyship.
If she is not eligible, where is the question of availability of a direct dependent for compassionate appointment?
Exactly. The petition number 1 is eligible.
Petition number 2.
No, she is not eligible
Then
for
who is the other direct dependent?
The petition number 1, Your Ladyship. Since she is the widowed daughter-in-law, as per clause 9.3.3 of the NCWA, if Your Ladyship may come to page number
There is
18.
order of rejection. Is not.
That is annexure 4 at page number 27 of the writ petition.
Annexure 4.
Yes, yes.
What is the date of death?
Your
Date of
Ladyship,
death.
the date of death is
14/6/20.
14/5/2010.
14/6/20. 17/7/2000 death is the date of his son, the husband of petition number 1.
Alright, just a moment. What is the date of death of the employee?
Employee, it is 14/6/2020.
2020. The son died on
17/7/2010.
17/7. No, it is date of death is 14/5/2010.
I'm sorry, but it is 14/5.
Two dependents are there, wife and widowed daughter-in-law.
Yes, sir.
When did you apply?
Your Ladyship, on 7/1/2021. The
Within
petition
time?
number 2.
Within time?
Yes, Your Ladyship.
What is the ground for rejection?
Your Ladyship, the rejection was done on the ground that आपको सूचित करना है कि मुख्यालय द्वारा
Page number, please.
Page number 27, Your Ladyship. Annexure 4.
Please place it.
महाशय, आपको सूचित करना है कि मुख्यालय द्वारा निर्गत पत्रांक संख्या BCCL PA6/2020-2315H दिनांक 7/5/2020 को के द्वारा यह सूचित किया गया है कि राष्ट्रीय कोल वेज एग्रीमेंट के तहत भारतीय कुकिंग कोल में कर्मी की सेवा काल के दौरान मृत्यु मेडिकल के आधार पर असक्षम अनफिट होने की स्थिति में आश्रित को नियोजन आर्थिक मुआवजा देने का प्रावधान है। वर्तमान में भारतीय कुकिंग कोल में अकुशल श्रम शक्ति की अधिकता है, जिसके कारण मृत कर्मी के आश्रित को नियोजन प्रदान करना, उनका लाभप्रद उपयोग करना मुश्किल है। उक्त परिस्थिति में आपसे आग्रह है कि आश्रित नियोजन के स्थान पर आर्थिक मुआवजा जो कि
How can this be done?
And you come to annexure 10. That is at page number 34.
Yes, 34.
Yes.
Yes.
I am reading the last paragraph. As the direct dependent, that is wife of the ex-employee, Srimati Jaswa Devi Salai, but she is not eligible to opt for compassionate appointment as she is more than 45 years of age as on the date of death of the ex-employee. But she is eligible to opt for monetary compensation as per provisions of NCWA. As such, her demand to provide compassionate appointment to the indirect dependent, that is Srimati Savita Verma.
No, she has an option. You can't refuse this.
Kindly come to 9.5 the annexure 8 to my counter.
You see, it is one thing to say that there is an eligible direct dependent.
When its monetary compensation is given in lieu of employment.
You cannot enforce monetary compensation when there is a dependent who is entitled for compassionate appointment.
We are not denying. What
You are denying.
We are saying that monetary compensation
You cannot. They have an option either for monetary compensation or for employment.
Kindly come to the relevant provisions.
They have an option or they do not have an option?
The widowed, the female dependent will have the option. If she is 45 years or less, she can take employment or monetary compensation. If she is above 45 years, she has the only option to take monetary compensation. And monetary compensation is given in lieu of employment. It is not a case, so we have to say that if the direct dependent, if no direct dependent is available for employment or monetary compensation, then only an indirect dependent would come into picture.
How do you classify this as indirect dependent?
Kindly see 9.3.3.
Page number 18 of my petition.
9.3.3. Yes.
Annexure page number 9.
Yes.
The dependent for this purpose means the wife, husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for employment, brother, widowed daughter-in-law, or son-in-law residing with the deceased and almost wholly dependent on the earnings of the deceased may be considered to be the dependents of the deceased. And so far as female dependents are concerned, they would be governed by 9.5.0. Kindly see 9.5.0.
Yes.
It clearly says employment or monetary compensation to the female dependent.
Yes.
So here my case.
Kindly read it.
Yes, ma'am.
Which clause are you reading?
9.5.0. Provision of employment / monetary compensation to the female dependent of the workman who die while in service and who are declared medically unfit as per clause 9.4.0 above would be regulated as under. In case of death due to mine accident, the female dependent would have the option to either accept the monetary compensation of ₹4,000 per month or employment irrespective of her age. In case of death of total permanent disablement due to other causes than the mine accident and medical unfitness under clause 9.4.0, if the female dependent is below the age of 45 years, she will have the option either to accept the monetary compensation of ₹3,000 per month or employment. In case the female dependent is above 45 years of age, she will be entitled only to monetary compensation and not to employment. So here is a case where is the widow is still alive, the direct dependent. She is more than 45 years of age, the management is ready to give her monetary compensation as per clause 9.5.0. Let's be. So specifically the female dependents have been dealt with under clause 9.5.0 of the National Code Wage Agreement. And the case of the management is monetary compensation is given in lieu of employment. You have to accept either of the two.
So do you want to say that if there is a female dependent who is above 45 years of age and there is a son who is eligible, you just let us know whether son would be entitled for compassionate appointment or he will not be entitled for compassionate. He would be.
Yes.
But since this lady who is claiming appointment, according to you, is an indirect dependent,
yes,
she will not be entitled.
She will not.
Does this particular clause make any distinction between direct and indirect dependent?
Yes, 9.3.3.
No, it does not say 9.3. It only says that in absence of these people, they will. It does not say indirect dependent. They still have to be fully dependent.
On the earnings of the deceased.
Yes.
Yes, ma'am.
They have to be fully dependent on the earnings. So there is no question of indirect dependence. There is no concept of indirect dependence. From where do you get this concept?
Who would get employment is 9.3.3.
That's it. That it is a matter of priority.
Yes, ma'am.
Yes. If there is a son, then the widowed daughter-in-law will not get it.
Yes.
Right? This is a sequence of priority. But it does not say that the other person, the widowed daughter-in-law, would become indirect dependent. She is absolutely direct dependent. She'll have to swear affidavit that she was dependent. You have to be satisfied that she was dependent on the earnings of the deceased.
Yes, that is a subject matter of inquiry whether she was dependent or
yes. So that is a separate thing altogether. So there is no concept of indirect dependent.
No.
In the sequence of priority, if the first category is not available, then the right flows to the second category. That does not make them indirect dependent.
Yes, but here is a case that the direct dependent is still available.
So there is no concept of direct and indirect dependent.
The wife is still available.
But she is not entitled for compassionate appointment.
But she is entitled for monetary compensation.
That's right. And you cannot make a distinction between a son who would be entitled for compassionate appointment and a widowed daughter-in-law and say that she would not be entitled for compassionate appointment, and you force the dependent wife to accept monetary compensation.
Let us conceive of a situation of this particular case. We are giving employment to this widowed daughter-in-law. Maybe after some years, she remarries again. What would happen to the widow?
If she remarries, then she will still be under a legal obligation to maintain the widow by virtue of her affidavit. You cannot take an affidavit that she would not marry.
No.
That affidavit you cannot take.
We cannot take.
But her undertaking that she will maintain the widow in case of compassionate appointment has to be honored, irrespective of wherever she goes.
But our case is that the widow is still available, being the direct dependent, and therefore the indirect dependent would not fall
If
for
you
consideration.
kindly consider Annexure 8 of my writ application. At page number
You are making some artificial classification which is not there in your.
page number 31, it should be Annexure 8 of my writ application. It was their letter which asked me to provide my dependency certificate.
No, we are not concerned with that. There is no dispute that you are dependent, but further they will have to further verify about your credentials or whatever it is. इसको कल लिखेंगे. ऐसा डिसाइड नहीं हुआ अभी तक कहीं. Respondent, no decision so far on this.
I also tried.
Every 4th case or every 10th case in my court is compassionate appointment. No decision so far on this.
So we have got cases of son-in-law.
Son-in-law by saying what?
That he is not the direct dependent, so he would not be eligible.
Son-in-law.
Son-in-law.
Not eligible.
Not.
That is a separate thing because as per NCWA is not eligible.
No, as per NCWA he is eligible.
In that case,
son-in-law or widowed daughter-in-law fully dependent upon the earnings.
Okay, provided he is fully dependent.
So I got cases against him for son-in-law, but not.
Who was not dependent.
Who was not fully.
That is a separate thing. होमवर्क आप लोग बहुत हमको दे दो. नोट्स बनाएंगे आप भी कोड कर दीजिएगा और सॉफ्ट कॉपी भी प्रोवाइड कर देंगे. परसों के रखते हैं. Letter counsel for the parties are present. The arguments have been concluded. The parties to supply short synopsis, list of dates by tomorrow. Okay. Post this case. Day after. छुट्टी है? मंडे को रख दीजिए. लेकिन आप कल तक कर दीजिएगा. आउट ऑफ टर्न मेंशन सर आपका जूनियर लोग अच्छा परफॉर्म करते हैं.
Sir, it's an honor to me.
Of course, it's an honor to you.
Yes. And my juniors, they were trained nicely.
They are.
And
They stick
only
to the
speak
records.
whatever is relevant. I have told them irrelevant बात बोलना नहीं. कोर्ट का समय खराब होता है. Time is precious.
I hope they remember you. आज के generation को देखते हुए. हमारे यहाँ सरिस्ता सिस्टम ही खत्म हो गया. That is the whole problem. किसी का ट्रेनिंग नहीं होता किसी सरिस्ता में.
Next item अगर ले लेंगे तो हम लोग खत्म 7.
क्या मैटर?
छोटा सा मैटर है.
इनका कोई मैटर छोटा होता है?
नहीं अब छोटा हो गया है. हमें एक्चुअली काउंटर एक फाइल करना था, बट इन्होंने सप्लीमेंट्री एफिडेविट फाइल
क्या होगा?
करके.
केस इन प्रोग्रेस?
I think so.
No, he will always say no. बताइए क्या हो गया?
They were referring to judgment here. This will not LPA number 371 of.
Just before that, his case is that he has been issued a charge memo with a suspension order. That suspension order, as per his affidavit now filed on 4th of March, has been withdrawn. Now he is on the rolls. He is working, and he is facing the charge sheet. Inquiry is in progress. Now he has taken a point in that The authority who has issued the charge memo is not competent. And in your Lordship's last order, your Lordship has noted a division bench judgment of this court which he is
Yes.
referring to.
But this I am not covered with this judgment, my lord, because this judgment has dealt the circular of 2003, my lord, and I am covered by this circular dated issued in the year 2021, my lord, that I have brought in my supplementary
So
affidavit.
where are both the circulars?
I have brought in one, my lord.
You have annexed both the circulars.
Yes.
Where you have filed it in supplementary affidavit.
In read petition, my lord, I have annexed the first circular issued in the year 2003 at page number 62, my lord.
And you have annexed certain document in as annexure 12. Absolutely illegible. I can't read
Only
it.
11
Annexure 12
annexure 12 is the
in the supplementary affidavit.
supplementary
Absolutely illegible. I can't read it.
Trace copy liable.
इसका टाइट कॉपी फाइल करिए. फ्रेश कॉपी कहाँ है आपके पास? And where is that judgment of the division bench?
Here it is.
And where is the this circular? Where is the circular which you are relying upon?
There are two circulars, one at page 62 of the writ petition.
62.
And the other is at page 22.
Page, now I am covered under this here, page number 22, my lord, of supplementary affidavit.
And what is this page number 16?
62.
16 of the supplementary affidavit.
Lord, this pertains to the earlier earlier circular, 25 August 2003.
So how do I read this?
I have a copy, my lord, fresh copy, because this is the document submitted by the management themselves in one of the another case, my lord.
You have a fresh copy, a typed copy.
In that circular, my lord, in that circular was that case was decided specifically because the circular issued in 25 August 2003 says that the competent authority has been nominated by the CFD CCL, and it was the contention in that case of the petitioner that the competent authority has not been nominated by the CMD CCL. But because the circular said that the competent authority has been nominated by the CMD CCL, that's why that case was turned down. But in this case, my lord, the circular appearing at page number 22, it has been issued by the approval of CMD, my lord. Now, what is approval, my lord? I have stated in para number 10 of my supplementary affidavit that the word approval as it finds its place mentioned in page number so and so of 2003-5 SCC 83 means confirming, ratifying, sanctioning, assenting, consenting to some act or things done by another. So my contention is this, my lord, that the power of nomination which is conferred upon the CMD CCL under clause 2.3 of the certified standing order, that has not been exercised by the CMD. This act has been done by some other authority and it has merely been approved. And the word approval is consenting to the act done by others. This act has been done by the other general manager P&IR. Next, my lord, para number 11, I have referred to the judgment, my lord.
Where is clause 2.3?
Yes, my lord. I have a next, my lord. In the writ petition, my lord. Page number 61. Clause 2.3, my lord. May I read?
Just read it.
Yes, my lord. 2.3. Competent authority means an officer specially nominated by the chairman cum managing director concerned by an order in writing for the purpose of these standing orders. Such orders shall be put on notice board and copies sent to the concerned registered trade union. So it categorically says, my lord, that the competent authority should be specifically nominated by the CMDCC. And my bone of contention that this nomination, power of nomination, has not been exercised by the CMDCCL. He merely consented to the nomination done by the others.
Where is the circular of 2003?
Page 62. Next page. 62, my lord. This was the circular, my lord, in reference to which the LPA was decided.
Yes.
It clearly speaks. First para, just, my lord, in pursuance and in terms of clause 2.3 of the certified standing orders applicable to all establishment of Central Coal Fields Limited, the following officers have been especially nominated as competent authority. Then the Honorable Division Bench read this sentence, my lord, and said, because the circular says that the nomination has been done by CMDCCL, that's why I will not interfere. Even otherwise, situation remains otherwise, my lord, that note sheet will speak. But I am not covered with this notification, my lord. Circular, my lord.
And where is circular dated 1/10/99?
99 was overruled, my lord. Otherwise, 99 was overruled. Just a bit. All earlier delegation, page 63, my lord. Down below para, my lord, just. Page 63 of writ petition, my lord.
Yes. Yes.
All down below, my lord, just one level. All earlier delegations of the subject stand superseded by this circular. And this is the 99 circular, my lord, in the standing order, my lord. Otherwise also, my lord, the note sheet speaks otherwise, my lord. This document was not produced before the Honorable Division Bench, my lord, which would have said that in fact power of nomination was never exercised by the CMD in that case also, my lord. Please copy, my lord.
So what do you want to say?
My lord, because I am not covered with this judgment, my lord. LPA judgment, my lord. I am
Wrongly decided because something was not placed.
I'm not covered.
You
I'm
said
not-
that something was not placed before the division bench.
Yes, my lord. These
So
docu-
therefore, we can say so. Can we say so? Can we observe that something
No,
was
no,
not placed
no,
before
no.
the division bench?
No, no. I am concerned with this circular, my lord, which has been issued in the
19th October 21.
21.
This
Because
circular empowers or it does not empower. Rightly empowerment is one thing, whether it is empowering or it is not empowering.
it is not empowering as per standing order, my lord. Because standing order is specific, my lord, that it should be nominated by the CMDCCL. And law is there also, my lord.
And you just tell us, in the departmental proceeding, whenever it is taken up, right, the charge memo being properly issued in terms of the standing order and whether the delegation is there or not, whether the party who is representing the management is properly delegated, competent, whether these issues are raised at that stage or not raised at that stage.
Jurisdiction issue, my lord.
No.
I can.
No, it is not just a jurisdictional issue. It is absolutely a mixed question of fact and law.
I am merely raising the jurisdictional issue.
That's
my lord.
right.
Because the
All
charge-
jurisdictional issue, there is no legal bar that jurisdictional issue of this nature cannot be raised before the authority concerned. And where is this circular dated 1/10/99?
My lord, this issue has been raised before the disciplinary authority also. my lord.
So you pursue it before the disciplinary authority.
But they have not come accepted to my contention, my lord. They are proceeding, my lord.
They are proceeding, they will decide everything.
I am before your lordship because I can challenge the jurisdictional issue, my lord. I can
You
challenge.
can challenge the jurisdictional issue and you can simultaneously proceed before the disciplinary.
Because they are asking me to present, my lord. I cannot say that I will not appear before them, my lord. And there are judgments in my favor, my lord. See, para number 11.
This circular dated 1/10/99 is not on record.
That has been superseded, my
No,
lord.
but Annexure 13 has been issued by referring to.
Yes, my lord. But that was superseded, my lord.
We do not.
Subsequent circular.
And that circular is also not under challenge in this writ proceedings.
Which circular?
This 21 circular is not under
I am
challenge.
not challenging that circular, my lord. I am not challenging that. My contention is that my nomination of the disciplinary authority by that circular is not as per clause 2.3 of the certified statement.
Yes.
I would submit that this circular which my learned friend is referring to, that can be answered in a disciplinary proceedings. He has raised that point. There also, he is participating in the inquiry also. He is appearing.
That will be decided
That
because
will be
these
decided.
documents are required to be seen.
Yes. And what is there, if
The
we see
standing
the,
order, the everything will be
Yes.
seen.
your lordship would see the division bench judgment. It has referring to that also. There is no difference. He says that if an order is passed by the governor, it has to be signed by the governor. Under the rules of executive business. Under the rules of executive business, all orders passed under the name of the president or the governor concerned, it is to be signed by the secretary concerned. These are the rules. Here what has happened is, this is, if we see the circular 2003, your lordship would see, page 62, it has been signed by the general manager. Here also, 2021, it is signed by the same authority, the general manager. So therefore what I am submitting is, that before the disciplinary authority, all these questions can be raised.
And this circular dated 1/10/99 was also subject matter of consideration before the division bench.
Yes. Para 21.
Yes.
Yes.
That was
Very much there.
That was
It
also
is
under
there.
consideration.
The subsequently that circular of 2003, it has
It's also
been-
there.
It is also there.
19th October 21 was specifically not there.
No, it was
But
not.
it is parallel to 2003 circular.
Yes, there is not much of a difference.
But
it has
अब
already
आप बैठ जाइए. 226 में it is my discretion. We have given you enough indulgence. You cannot proceed parallelly at two forums. WPS number 6386 of 2023. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that a jurisdictional issue is involved in this present case inasmuch as the charge sheet cum suspension order has been wrongly issued, and the same has been issued by an authority who was not competent to issue such charge sheet cum suspension order in terms of the certified standing order clause 2.3. The learned counsel has submitted that through the supplementary affidavit dated 4/3/2024, it has been brought on record that so far as the suspension order is concerned, the same has been
Revoked.
And
He has been allowed to join.
And the petitioner has been allowed to join, but the grievance of the petitioner has is not yet satisfied inasmuch as the charge sheet has been issued by an authority who is not competent. The learned counsel for the respondents has opposed the prayer of the petitioner and has submitted that the petitioner has brought on record the circular dated 19th October 2021, which is in almost the same lines as that of the circular dated 25th of August 2003 dealing with delegation. He also submits that the circular dated 25th August 2003 was subject matter of consideration in LPA number 371 of 2020, and the point of delegation has been decided against the employee. He has also submitted that the circular dated 19th October 2021 also refers to an earlier circular dated 1/10/1999, which was also considered by the Honorable Division Bench while deciding LPA number 371 of 2020. The learned counsel has further submitted that departmental proceeding is going on and the petitioner has raised the plea of the jurisdiction before the disciplinary authority, before the inquiry officer, and these are disputed questions which are required to be gone into after taking into consideration the various documents regarding delegation of power, and therefore the present writ petition is the issue in this case be not decided at this stage. This is over and above the plea that the issue has already been decided in LPA number 371 of 2020, although the circular dated 19th October 2021 as annexed with the supplementary affidavit was not the subject matter of consideration in LPA number 371 of 2020. At this, the learned counsel for the petitioner has submitted that the jurisdictional issue be decided, although he has not disputed that the plea of jurisdiction has been raised before the inquiry officer in which the petitioner is already participating. After hearing the learned counsel for the parties and considering the nature of dispute involved in the present case, this court is of the considered view that the issue of jurisdiction which is involved in the present case is itself a mixed question of fact and law, and such issue cannot be decided at the threshold in writ jurisdiction. Without observing any further, this writ petition is disposed of, and with an observation that the issue of jurisdiction which has been raised by the petitioner before the inquiry officer shall also be considered by the inquiry officer in accordance with law, and dismissal of this writ petition will not have any bearing with regard to the issue to be decided by the inquiry officer. That's it.
Corruption Direction Case Item 34, the rupee is feasible to 0 of 2023 along with 35.
Yes.
Serial number 49 on the same issue.
49. Okay. Same issue, same order?
34, 35, 49.
34, 35
and 49.
सीरियल नंबर लिखिए 34, 35 and 49 और ऑर्डर का नंबर बताइए
WPS 4936 of 23.
WPS number 4936 of
2023.
2023. The learned counsel for the parties have jointly submitted that the point involved in the present case is squarely covered by judgment passed by this court in WPS number 4936 of 2023. They jointly submit that these writ petitions be dismissed in terms of the said order. Correct? Accordingly, these writ petitions, in view of the joint submissions made by the counsel for the parties, these writ petitions are also dismissed in terms of the order passed in WPS number 4936 of 2023. What happened in Supreme Court? You have gone to the Supreme Court. You indicated on that day you withdrew one writ petition. Somebody said I don't know. Just a minute. This is arising out of the same advertisement?
That matter, the matter is pending before the Supreme Court with respect to the cut-off date in Soni Kumari case.
Yes.
It is pending. Many persons have filed the miscellaneous application in the contempt case of Soni Kumari.
Okay.
So it is been pending, not been heard.
Not
it has been registry for curing of.
Because of that cut-off date of 3
Yes.
months and no further order to be passed by the High Court.
Yes, Lord. Because of that observation, the High Court have not passed the order, and they have went to the Supreme Court that they are still not complying the order of the Supreme Court in true literal spirit. They published a new cutoff which was not actually allowed. It was that taking that particular cutoff, you publish a state merit list because of that confusion.
The facts are same. Have you tallied this? I will tally it before I correct. I tally everything.
Yes,
I have
only
just
the roll numbers
recorded on whatever you have submitted. उसका कुछ ऑपरेटिव पोर्शन हम लोग इसमें कोट करेंगे, ठीक है? Is one more mention, please?
Yes, I mentioned in my model. Serial number 39.
Because my learned senior requested this matter for taken up tomorrow. He has gone for a Sharad.
What is it?
Only since that Lords received a newspaper that tomorrow they are going to publish the final result and the appointment letters to Lords. And Lord, this issue is broadly covered by the judgment of Honorable Supreme Court and different other High Courts of full bench of High Court, which is upheld by the Supreme Court. The issue is with respect to the minimum qualification.
So what do you want?
But this matter should be heard and Lords.
It will be heard, but on the basis of whatever document you are producing, by
That is a
paper
newspaper
publication, you cannot do anything about it. It will be heard. They were saying that they are in the process of filing a counter affidavit.
Because we have filed a counter affidavit has been filed.
Pleadings are complete.
Pleadings and complete. The counter is complete. I don't need to file rejoinder now. Counter affidavit says enough. Various other petition is also pending with having the similar pair, but this is the Lords. So this will be decided in other cases. So we having the same effect.
You want this matter to be taken up tomorrow?
Tomorrow.
Who will argue?
Mr. Manish Mishra.
Sorry?
Mr. Manish Mishra.
Have you prepared any note?
Prepared a compilation of judgments, no, prepared a
File it.
Yes, I'll file it. And this is a
Give me right now because I need to
Yes,
study
compile.
more than you study.
and this is a compilation of judgments.
Note.
Notes, I'll short 2-page notes by 4:30 I'll provide.
Yes, please do that. You are posting it tomorrow?
Yes.
Is there any private respondent here?
No, not yet.
Private respondents are not there, but at large it will affect the private respondents.
Till date
So,
the
the
appointment
right
letter has not been issued.
crystallized in favor of
Rights have not
anybody.
crystallized.
Appointment letter has not been
Not been
issued.
crystallized.
But
Result has not been published.
So under such circumstances, so those persons who are having diploma, they have been disqualified.
No, what they are doing, the minimum qualification was diploma. After 10th they do the after 10th they do the diploma course, but the direct BTech degree holder has also filled up the form notes, and they have been accommodated, my lords. And the GSSE has said they have itself interpreted the rules of the state. No, as per rule, we think that direct BTech degree holder will be considered. However, in the state counter affidavit, they have not admitted. They are still saying that no, this rule can be interpreted by this department. This rule can be interpreted by this department. But the rule has been framed by Department of Personnel. So the state is
That
silent.
rule is under challenge.
No, rule is not under challenge, my lords. We are saying the rule is correct. GSSC is wrongly interpreting the meaning of the rule. What is the rule? That diploma holder is the minimum qualification and the उच्च तकनीकी योग्यता भी आवेदन के पात्र हो. तो उच्च additionally उच्च तकनीकी
So
योग्यता
they are
persons who after diploma who do the 3-year BE course, that will be eligible. By taking this clause, they have allowed the direct BTech degree holder to participate in the examination.
Who do not have a diploma.
Who do not have the diploma, which is a minimum requirement for that engagement. And this issue, because of this issue, huge number of BTech degree holders has applied, my lords, and since they know the academic, they are good at academic, they get the results, my lords, and because of these diploma holder, because my lord, there are more than 1 lakh diploma holder, and they are only eligible for the post of junior. There is no other post for which they are eligible in entire country. And this issue has
Do
been.
you have any, this is for junior engineer?
Junior engineer.
And for direct recruitment in assistant engineer, maybe
Assistant and direct BTech degree holder is eligible. They are eligible in.
Their eligibility criteria is also mentioned in the same rule?
And that is a different rule. There is that you have to have the BTech degree holder or BE for assistant engineer.
Where is that rule?
That BTech, Lord, this is not annexed, Lord. I'll bring that rule.
No, where is
for
this,
assistant engineer.
Where is this rule? Where
Yes,
is the rule annexed?
Yes, Lord. Rule is
The
annexed.
minimum qualification?
2015 rule, which was
Where is
amended,
it?
Lords, later and.
Where is it?
85, Lords, is start.
No, you just tell us the relevant
The relevant
clause.
part is 86. Page 86. Five to 2.
Read it, please.
Yes, 5 पर पात्रता अर्हता का निर्धारण. First is उम्र, second is अभ्यर्थियों को आयोग में आवेदन पत्र जमा होने की अंतिम तिथि तक वैज्ञानिक शैक्षणिक योग्यता अर्थात संबंधित विषय में डिप्लोमा प्राप्त करना आवश्यक होगा. This is which is later on amended, Lords, in the year 2019 by Department of Personnel, in which one line is added, उच्च तकनीकी योग्यता, which is at page number 95. Relevant is 96.
Yes.
Yes, I will start from bottom line of 95.
अभ्यर्थी और उनके आवेदन के लिए झारखंड कर्मचारी आवेदन नियमानुसार पद के लिए न्यूनतम शैक्षणिक विधि द्वारा पदस्थ केंद्र सरकार या राज्य सरकार द्वारा मान्यता प्राप्त संस्था अखिल विद्यार्थी AICTE द्वारा मान्यता प्राप्त संस्था सिविल विद्युत यांत्रिक कृषि अथवा संबंधित
भाई आपका तो पेज ही नहीं है
96
कहाँ से क्या पढ़े
सॉरी 96 मिनट्स
96 ऊपर लगा हुआ
यस
हाँ kindly read it. अभ्यर्थियों के लिए उनके
आवेदन पत्र झारखंड कर्मचारी चयन आयोग द्वारा विज्ञापित आवेदन जमा करने की अंतिम तिथि तक नियमावली की अनुसूची 1 में पद के लिए न्यूनतम शैक्षणिक विधि द्वारा स्थापित एवं केंद्र सरकार राज्य सरकार द्वारा मान्यता प्राप्त संस्था अथवा AICTE द्वारा मान्यता प्राप्त संस्था से सिविल विद्युत यांत्रिक कृषि अथवा संबंधित अभियांत्रिकी में डिप्लोमा की उपाधि उच्च तकनीकी योग्यताधारी भी आवेदन के पात्र। So the JSSC is misinterpreting this particular clause, and they are not considering that minimum qualification is diploma. Minimum, then you have the higher qualification, you can be eligible, but the basics should be diploma. And Lord, this confusion is arose in entire India with respect to junior engineer appointment, and entire High Court writ petition has been filed upheld till Supreme Court. They have decided in favor of diploma holder.
Show me one of them.
Yes.
Patna. It is
Patna, yes, upheld till Supreme Court notes.
1990. Page number 19.
Yes, notes. Start from page number 19.
What was the
relevant?
Where is the relevant notification?
Yes. Relevant is starts from page 44. 2, 3 paragraphs.
44.
Yes, notes. 44 notes, second paragraph. In the mid note, I will start. We also overlook this argument of the learned counsel.
No, I want to see the rule.
So
I want to see the rule which was under consideration in Patna.
the rule is at notes, page number 43. It is quoted in office order so and so full time. One is that full-time 3-year diploma in electrical from a recognized institute college duly recognized by the state government, central government, approved by AICTE. JE Civil full-time 3-year diploma in civil from a recognized institute college duly recognized by state government, central government, approved by AICTE. Mode of selection so and so.
Both is diploma only.
Yes, no diploma holder.
But there is nothing like engineering.
There is nothing like engineering.
Now, how do you use this judgment in your favor?
No, in my favor, not because in these cases also they have the petitioners who are the direct BTech degree holder. They claim that no, since we are the direct BTech, we are higher than the qualification than the diploma, so we will be included.
The rules are absolutely different.
Yes.
It requires a diploma irrespective of whatever.
Yes, ma'am.
In both the clauses, there is diploma.
Here also, ma'am, minimum qualification is diploma. Then, uch takniki yogyata hai.
It is one thing to say that minimum qualification is diploma, and in addition, there could be.
They are eligible have.
Uch takniki yogyata, ma'am. Other judgments of Supreme Court has also said.
आप हमको एक judgment दिखाइए ना which covers your issue. You say that so many judgments. This rule does not gel with your submissions.
So far as my lords,
कल तैयार हो क्या?
Which technique योग्यता? This
कल
would be
तैयार-
the this
कल तैयार हो क्या?
this particular rule is
There is
not
also surviving parent rule underneath the lords.
Because my lords, the higher qualification will not presuppose the lower qualification, my lords.
It is not in the same ladder.
Same yes, my lords. Same
It is
channel.
not in the same ladder.
Yes, my lords.
So therefore, when they say that that BTech holders can also apply,
Yes, my lords.
that does not mean that the BTech holder should first do their diploma and then go for BTech degree and then they will apply. How many such
Neither
candidates
say-
are there who have a diploma as well as engineering? एक भी मिलेगा आपको?
Because
You just tell us. Isn't it absurd when we see the real social situation? I have not come across any person.
No, there are many persons because
Many
after
persons.
junior engineer for the post of assistant engineer, there is a rule that if you have the engineering after diploma, then you will get the promotion by quota. That AMIE quota 10% reserved in the state of Jharkhand, also in the state of Bihar. So they are motivated to do this engineering after completing the diploma. They get also holidays by the rule itself in the department.
We'll see that.
Yes,
Kal aa jayegi.
Lordship, serial number 9. There are some defect. It may be taken after 1 week.
Sir?
9 में defect.
Defective है आज defects भी लगे हुए हैं और क्या हो गया
उसमें defect
इसमें post tomorrow कर दीजिए
नहीं
at the request of the council for the respondents
हम नहीं बात
आपके केस में नहीं बताइए क्या हो गया आपके defect
मेरा में defect है तो next week रख दिया जाए meantime I will remove it.
Learned counsel for the petitioner prays for and is granted time till 28th March to remove the surviving defects. Post Premature. Post on 2nd April under appropriate heading if the defects are removed within the stipulated time.